Hello and welcome to the BLC podcast. My name is Rory O'Neill and I'm joined in the box today by Advocate General Gerard Hogan. Justice Hogan is one of the Advocate Generals at the Court of Justice of the European Union. Before being appointed in 2018, he was a judge in Ireland. Since 2010, he sat in the High Court, and since 2014 in the Court of Appeal. He is also a professor of law at Trinity College Dublin, and before joining the bench, he was a practicing barrister. In Ireland, he is considered the leading authority on the Irish Constitution. Gerard, thank you so much for joining us today.
Pleasure.
So today we are going to be talking about the horizontal direct effect of directives in European Union law. And Advocate General Hogan is going to be talking us through the evolution of the principle from the times of Marshall, Marleasing, Frankovic, and then we're going to look at those recent CJA EU judgments in Smith, Eggenberger Bauer, Dansk Industry, and Cresco investigation. Just to get us started on an opener so that our viewers can have an idea of what the issue might be, because some of our students are outside of the European Union and may not be familiar with the core issues, or they might not have studied EU law yet. And what is the general issue when it comes to the horizontal direct effect of directives?
Well, by virtue of Article 188 of the TFEU, Treaty on the Functioning of the European Union, directives are a type of legislation which is addressed to whereby member states are expected to bring their own law into conformity with the requirements of the directive, but they are permitted what's called a choice of form and method. So there's no uniform method whereby this is done in the member states. What counts really is that the ultimate goal and the requirements of the directive are transposed into their national law, but that's how that is done is left by the treaty to the individual member states. Now, they're normally given a transitional period with which to do this, often in the region of months, years, to do this, and that is to be contrasted with the other principal form of legislation at EU level, which is by regulation. And a regulation is what's called directly applicable to the member states. In other words, the union legislator has got the capacity to legislate under certain circumstances by regulation, and that applies to everybody. It applies to the member states, but it also, in principle, can create rights for individuals which they can enforce as against other individuals. Now, the specific problem in terms of directives is that, at least as originally conceived, the directive system was addressed to member states. And it was a new type of legislation which didn't really exist before the European Union was created. And therefore, one can anticipate that there were a number of problems in the initial years of the European Union to work out what, if anything, was the difference between directives and regulations. And in a series of decisions from the 60s, a major decision was a case called Von Dunn and the Home Office in 1973-74. The Court of Justice essentially held that under certain circumstances, a directive could have direct effect as against the member state. So where the member state was had failed in its obligation to transpose the directive into national law, under certain circumstances, an individual who would be a beneficiary of the directive could say that the directive was clear, precise, and unconditional, intended to create legal rights in that person's favor, and the time for transposition of the directive had ended. In those circumstances, there would be what's called direct effect. And you can rationalize that on any number of grounds. I mean, one of them is that a member state can't take advantage of its own wrong. And that if it was supposed to transpose the directive by a given time and a given date, well, then it can't scarcely be heard to complain if an individual can then sue it and say, wait a minute, I had a right under this particular directive, you failed to transpose it by a particular time, and now I can avail of that right as against you. The problem that I suppose we're going to discuss this in this course of this lecture is a slightly different one. Up to now, I've been speaking to what's called vertical direct effect. That is, right up as against the member state, individual is against the member state. But the real problem arises in the context of what's called horizontal direct effect. That does it confer rights? Does this untransposed directive confer rights as against a third party in which you might be in litigation? And in a very important case called Marshall and Southampton Teaching Hospital in 1986, the Court of Justice rejected the idea that there was this form of horizontal direct effect. And it did so effectively on, you might say, rule of law grounds, that the obligation to transpose the directive had been imposed on member states. The third party had got nothing to do with the fact, the private part, nothing to do with the fact that the directive mightn't have been transposed. And therefore, why should that person who might be following the law in their own country, why should that person be, in a sense, penalized by having direct effect of a directive which was not yet in force in their member state and which was not their responsibility. So that was, if like, Marshall and Southampton Teaching Hospital. And then in another case from around that period, slightly later, case called Ficini-Dori, in 1990, the Court of Justice said that gave another reason. It said this would amount to recognizing a power in the European Union to enact obligations for individuals with immediate effect, where it has competence to do so only when it is empowered to adopt regulations. In other words, in Ficini-Dori, the court also focused on the fact that under the then, well, as it was the EEC treaty now, TFEU, there's a sharp distinction made between regulations on the one hand and directives on the other. And if you have horizontal direct effect, the court was saying in Ficini-Dori, you're essentially collapsing the distinction between regulations and directives. So up to a case which I'm sure you're going to ask me about, Marleasing, up to that point, the situation, I think, was quite clear. There was a distinction between directives and regulations. You could have vertical direct effect in the case of directives. There was also an issue as to what was the state or an emanation of the state for this purpose. That's a slightly different question. Sometimes what was the state was given a very expansive interpretation. But in principle, where you were dealing with a private third party in litigation, you could have no horizontal direct effect so as to impose an obligation on that private third party by virtue of the directive.
Okay, so that sounds pretty clear, that because directives are addressed to the member states, it's not possible for an individual to rely on an unimposed directive to establish obligations against a private person. And that rule seems to have continued quite consistently in the Court of Justice's judgments until today. So when did that become a problem? So why is that still controversial?
Well, I suppose it is to some degree controversial because there have been several strains of authority, and perhaps we could pick up the pieces with or start with what I think was a divergence is in the case of Marleasing from 1990. And this is a case which is best known for the principle of interpretation conforme, or conforming interpretation, that where the court held there was an obligation on the courts of the member states to give the interpretation so far as possible. Now, those are critical words, to ensure that national law conformed with the directive. What I see has happened with ups and downs in the last approximately 30 years since that decision was given, is that you see the court perhaps at some stages pushing the interpretation conforme, the Marleasing style interpretation. At other times it says that there are limits to this, because you can't do it. You can't say, if you like, the national law is black when it says white, in the aid of having this interpretation conforme. And then in recent times, there's been yet a further complication, which is a distinction drawn by a series of cases in 2018 and last year between whether you can have horizontal direct effect in cases where the directive is intended to give effect to the charter. And what I'm going to suggest is this is, I'm going to say something, if I may, about Marleasing, and then jump, if everybody will bear with me, jump ahead to the recent cases. Now, to do this properly, I'd probably need to speak for 3 or 4 hours to cater for the ups and downs. But maybe I just focus on Marleasing and then jump up to the more recent cases. You see, I think the problem with Marleasing is that it's a very natural tendency in judges and in lawyers and in law students is to understand a case for a particular proposition and then perhaps not go back and look at what actually happened in Marleasing or in the case in question. And I think that's what happened in Marleasing, because people say, Marleasing interpretation conforme. We don't actually go back to see what was an issue in that case and see what was actually decided. And in Marleasing, it concerned a provision of the Spanish Civil Code. And these provisions of the Spanish Civil Code allowed the Spanish courts to nullify the establishment of a company for what was called for cause. In other words, they had the power to hold that the establishment of a particular company was for a fraudulent purpose. That it was a sham company designed to defraud creditors. And that was what was at the heart of Marleasing, because this was a dispute between two Spanish companies in which the plaintiff contended that the principal defendant company, a company called La Comercial, was in fact a sham company established by another entity called Barviesa. And Barviesa, it was said, had transferred its assets to La Comercial. So Marleasing wanted La Comercial to be, the establishment of La Comercial to be nullified on the basis that it was simply a vehicle for what was contended to be the fraud of Barviesa, because Barviesa wanted to transfer its assets to La Comercial and thereby get out of its debt obligations to Marleasing. Now, Marleasing, this company should be nullified under the provisions of the Spanish Civil Code, but there was a twist in the road, because La Comercial said that these proceedings should be dismissed because under the terms of the first company law directive, there was a list of circumstances in which a company could be nullified and This was not one of them. In other words, that under the terms of the first company law directive, you could set, the court could set aside the establishment of non. Now, there was a further problem, which was had not actually transposed the of company law directive, even though the time for doing so had in fact expired. So the issue came before the Court of Justice, and the Court of Justice said that the duty on the member states, including the courts, in applying the national law, the national court is, and I'm quoting, is called upon to interpret it, is required to do so as far as possible in the light of the wording and purpose of the directive in order to achieve the result pursued by the latter and thereby comply with what is now Article 288 of the treaty. Now, the court then went on to say that the Spanish court must interpret its own law in conformity with Article 11 of the First Company Law Directive, and that any interpretation of that law which was at variance with the terms of that directive was precluded. So, outside, this seemed an unexceptionable proposition that you've got to interpret the directive in accordance with interpret national law in accordance with the directive as far as possible. But the difficulty here, I think, is that it's a type of horizontal direct effect by the back door, because what really was happening was that under the guise of interpretation, in reality, the Court of Justice was telling the Spanish courts, you can't, you must, or you can nullify the establishment of la comercial, and you have to interpret your own national law in a way that conforms to the First Company Law Directive. The difficulty was, I think, was that the terms of the Spanish civil law were not ambiguous. They were not open to that type of interpretation. They effectively said black when the Court of Justice wanted them to mean white. And when the case went back, the court said, well, you must interpret your national law in conformity with the directive. And to my mind, it was a form of horizontal direct effect, because look at it from the perspective of Mar Leasing. They contended a perfectly good cause of action under Spanish law. True, this cause of action was not in conformity with the terms of Article 11 of the First Company Law Directive. Well, that wasn't their responsibility. That wasn't their fault. And yet the court was saying, Court of Justice was saying, Spanish courts, you have to interpret the First Company Law Directive, give primacy in essence to the First Company Law Directive under the guise of this interpretation of national law. Now, I think one of the difficulties here is that in any ordered legal system, there has to be a direct link between legal default and legal liability. And in a way, Mar Leasing was paying the price for the inaction, which was the exclusive responsibility of the Spanish state. So I think that's one of the difficulties with Mar Leasing. Now, there have been a whole series of cases since Mar Leasing where it's been given, if you like, there's been given full force and effect. There have been other cases where what's called the contra legem doctrine has blunted the, if you like, the directness of Mar Leasing. Contra legem is saying that there are limits to Mar Leasing. That if the national law is clear and precise, then you can't, under the guise of interpretation, say black is white. And in those circumstances, Mar Leasing doesn't apply. so the debate has gone on for 20, 25 years since Marleasing, forward and back. And I would have said, if we'd been doing this interview perhaps 5 or 6 years ago, that the tide had shifted away from Marleasing to some extent. Certainly, it's a very useful doctrine. Nobody decries that or says to the contrary.
Can I interrupt you for 1 second, Jared?
Of course. Yeah.
There's the signal is a bit weak. Would you mind if I turned off your camera? Because I think then
Sure.
the sound would become a bit clearer.
Okay.
Okay, what were you saying a moment ago about you thought of 5 or 6 years ago that we would have been moving away from Marleasing?
We were moving away to some extent from Marleasing. Not saying that it isn't a very useful document, but where two interpretations are reasonably open of national law, that you give it an interpretation which conforms with EU law. Don't think there's any difficulty with that. The problem arises is where the national law is clear and doesn't admit of this dual interpretation. What happens then? And I think that the contra legem doctrine had gathered a lot of ground in the 15, 20 years after Marleasing, to the point whereby, had we been doing this interview in, say, 2014, 2015, one could have confidently said that Marleasing had been tempered by the contra legem doctrine. But there have been a series of cases now in the last 2 or 3 years where we seem to be moving in two different directions, and I'm going to mention 2 or 3 of them. The first is a case called Danske Industry, or DI, and that concerned the compatibility of an aspect of the Danish pensions law with the Equal Treatment Directive. And the Danish courts had said they couldn't give their own domestic legislation in interpretation with the terms of the Equal Treatment Directive. But the Court of Justice was very, very reluctant to accept this, because it really went on to say that the requirement to interpret national law in conformity with EU law entails the obligation for national courts to change its established where necessary national law of the directive. It went on to say, really, that just because the Danish courts had interpreted their own law, their pensions law, in a particular way, was no, they should go back and, in a sense, try harder, and were effectively obliged by the Court of Justice to seek to interpret that pensions law in a manner which is compatible with their protests notwithstanding. So, I mean, that was a straw in the wind that the court perhaps was going back towards full-blown Marleasing. And we've seen that as well in a series of other cases, years. These are directives which are, in cases involving directives, which are designed to give effect to provisions of the, which can be said to give effect to some of the obligations contained in the Charter. And I'm going to mention 2 of them now. I'm going to contrast this. Their cases, Bauer and Ager, one had,
Can I interrupt you again?
Cresco investigation.
Sorry, I think I might need to just summarize what I think you just said, because the signal broke up quite a lot. So I think at this stage now you've moved on to talking about those cases involving the application of directives which implement aspects of the charter or articles in the charter. Is that right?
Yeah.
Okay. Okay.
Can I start?
Yeah. Go ahead. Go ahead.
What we've seen in what has been a trend over the last 2 or 3 years is a series of cases, Bauer, Egenberger, another called Cresco investigations, where the court has had to deal with a situation where the directive at issue was giving effect to a charter right. Typically in matters such as, say, employment leave, non-discrimination, and so forth. And where the directive in question either mirrors or gives effect to a provision of the charter. Now, let me just give, all of these cases are very much in the same vein, and I'm going to mention one of them. A case called Cresco Investigations from 2019. And that concerned a provision of Austrian law which directed to give employers to give additional payments to employees who worked on Good Friday. Mm-hmm. Now, in Cresco, the employee in question was not, however, one of the 4 named Christian denominations who would get the benefit of this additional payment if they worked on Good Friday. Perhaps I should have made it plain that the Austrian law said that if you were Roman Catholic or one of the main Protestant churches and you worked on Good Friday, you were entitled to this additional pay. What about an employee who was not a member of one of those churches? And that's what arose in this case. And when the Advocate General, Bobek, had no difficulty saying that this Austrian law violated the non-discrimination provisions of the Charter. The question was, what remedy would be supplied in these circumstances? And he said you couldn't, in essence, interpret either the Charter or the relevant directive as imposing an obligation on the employer to pay the additional salary or the additional bonus to the employee, because that was the responsibility of the Austrian state. In other words, the employer had just simply followed the law. And Austrian law was found to be incompatible with the terms of the Charter because it had discriminated in this fashion.
And if that was possible, would that have been an example of horizontal direct effect?
Well, exactly. But the Court of Justice, now in a case which admittedly concerns principally the Charter rather than a directive, nonetheless had no difficulty saying that the employer was responsible for paying the bonus to the individual, even though this was not provided for by Austrian law, and even though the employer had no responsibility for the fact that Austrian law was incompatible with the Charter. And you had found this similarly in these cases in Bauer and Egenberger and Max Planck. There's a series of German cases involving essentially discrimination and leave entitlements. And if you like, the theme that emerges from these cases is that in effect, a form of horizontal direct effect would be permitted, even in the case of directives, where the directives are giving effect or mirroring Charter rights. Now, there is something of a problem there because for many people, the Charter is like is addressed simply to the member states. And Article 51.1 of the Charter says that the Charter is only addressed, this is the Charter Fundamental, EU Charter of Fundamental Freedoms, is addressed to the member states only when they're implementing union law. So, you know, one view is that the Charter is a bit like directives themselves, only concerned with member states, and the obligations are addressed to member states only. But in the Bauer case, the late Advocate General Yves Bott, who sadly died last year, said that while the Charter was principally concerned and addressed to member states, it wasn't exclusively addressed to member states. And the court agreed with him. So that these cases now seem to suggest that where you have directives which give effect to Charter provisions, then where they're clear, precise, and unconditional, they can be enforced horizontally as against third parties. Now, that can be contrasted with another case called Smith and Mead from 2018. Because, as we shall see in a moment, the court uses its decision in Smith to contrast that decision with what I'll call the Charter horizontal direct effect type of cases. Mm-hmm. And Smith was originally, it was an Irish case where Irish law provided that if you were driving a van, you had to have insurance, but not in respect of anybody who was sitting in the back of the van without a fixed seat. I think all of us are kind of familiar with these vans, which you might have, say, 2 seats in the front and then a hold in the back, which is principally for, you know, goods and equipment and things like that. And that the Irish law said, well, if you're traveling in the back of the van and not sitting on a fixed seat, there's no obligation to insure you. In Smith, what had happened was that in 1999, Smith was traveling as a passenger in the back of a van where there was no fixed seat in the back of the van, and there was a terrible motor accident in which he suffered appalling, life-changing injuries. Now, he sued for negligence, the driver of the vehicle. And the question was whether or not the insurance company was in effect obliged to pay out the damages in respect of Smith. Because the driver of the vehicle had insurance which complied with Irish law, which said, yes, you've got to insure for the front seat passengers, but not in essence for the back seat passengers because there's no fixed seats there. And remember, Smith was a back seat passenger. So the insurance company said, we're not under an obligation to pay because under the policy of insurance, this was not a risk that we had undertook to underwrite. So the case came before the Irish High Court, and in the High Court judge applied Mar leasing principles and said, in essence, that Irish law had to be interpreted in a way which conformed with the Third Motor Insurance Directive. Now, I should have said, sorry, to begin with, that the Third Motor Insurance Directive required that all passengers be insured, not just simply those in the front seats. And Ireland, in a case called Farrell in 2007, had been found guilty of breaching the Third Motor Insurance Directive by the Court of Justice itself. So there was no doubt that Ireland was in breach of the Third Motor Insurance Directive by not stipulating that everybody be covered for insurance and not just simply those in the two front seats. The problem was could the insurance company, which had complied with Irish law as it existed at the time and had underwritten the risk in conformity with Irish law at the time, could it be required to pay out as if it had insured the backseat passenger? And that's what happened in the High Court. The High Court judge said, at first instance, there's an I'm applying Mar leasing. I'm going to apply to read Irish law in conformity with the directive, and the directive requires that everybody be insured and not just simply the front seat passengers. The insurance company appealed to the Court of Appeal, and as it happened, I was a member of the panel and indeed wrote the judgment in the case. And we took the view that this was not possible this is not a possible interpretation of the Irish law, that the Irish law had said in very clear black and white terms that there wasn't an obligation to insure backseat passengers. Now, nobody disputed, but that was ultimately found to be contrary to the terms of the Third Motor Insurance Directive. But the question was, what remedy, if any, were we supposed to give in these circumstances? Because the Smith case really is a classic paradigm of Mar leasing. The law says black, the national says black, as it happens, the directive says white, and there's a third party, an insurance company, which followed the Irish law, not the directive, and should it be responsible to pay this very large sum of money to a very, very deserving plaintiff? So the case came before the court. So the case came before the Court of Justice in 2018, and the Court of Justice took the view that where the directive is giving effect to general principles of EU law, then even in disputes between private parties, it requires the national courts to disapply national provisions that do not comply with that principle, where they consider it as impossible to interpret those provisions in a manner that is consistent with EU law. So what the court said in Smith was, if we look at all these recent cases, DI and a whole series of other cases, that where they concern a general principle of EU law, and it reminded us that in DI it concerned non-discrimination on grounds of age. Well then, if you like, you've got full-blooded Mar leasing, which involves the disapplication of national law, even in a case involving a private party. But it said that the present case was different because the motor insurance directives did not involve a general principle of EU law. It couldn't be regarded as giving what is described as concrete expression to a general principle of EU law. And it said that in these circumstances, full-blooded Mar leasing didn't apply. There wasn't an obligation to give an interpretation conforme in that type of situation. And so what emerges, it seems, from a consideration of all these recent cases, Smith, Bauer, Egenberger, Cresco, I think it can be summarized as follows, is that where the directive involves either a charter provision or a general principle of EU law, then even in a case involving a third party, a private third party, which bears no responsibility for the national law in question, the national law can be overridden in order to give effect to the provisions of the directive. So that meant, for instance, that in DI, the employers were obliged to give effect to the non-discrimination provisions of the directive, even though Danish law had said otherwise. In Cresco, the employer was obliged to give the bonus payment for working on Good Friday to everybody, and not just simply the members of the Christian denominations mentioned by Austrian law. And why? Because these all concern fundamental principles of EU law, or general principles of EU law, and therefore moral leasing applies with full effect. On the other hand, you have a case like Smith, where it concerns certainly an important directive, but not one that is fundamental in that sense. And in that situation, the court, distinguishing the other cases, says that that principle of moral leasing doesn't apply. So therefore, if you like, the contra legem doctrine comes back into play, and the national court is not obliged under the moral leasing doctrine to disapply national law, and instead it can say, well, look, the national law is clear and we can't give it a moral leasing style interpretation. So that seems to be the position as of now, that the court is drawing that new distinction between cases involving fundamental principles and charter provisions on the one hand, and those that don't on the other.
When Smith and Mead returned to the Irish court, was that then a case where the national law, which we already know was contrary to EU law, would have had to have been applied in a private action?
Well, as it happens, the matter was taken out of our hands because the parties settled the case.
Okay.
The Irish state was also a party to the proceedings, and there would have been the prospect, I suppose, of a Frankovich damages action against Ireland for failing to transpose the national law in a correct fashion. But what I think one can infer as a result of the decision of the Court of Justice is that the private insurance company wouldn't have been responsible to pay out the damages because the national law was clear and precise at the time, and it wasn't responsible, in a sense, for the failure of the Irish state to transpose the directive in a proper way.
Okay. Well, I'm glad you brought up Frankovich, because I wanted to ask you a question about that. Because when I read Advocate General Bobek's opinion in Cresco Investigations, the impression I got was that he would have preferred that the cause of action was based on state liability, using Frankovich against the state rather than claiming those benefits for not working on Good Friday, for having to work on Good Friday against the employer. Where do you stand on that?
Well, obviously I have to have an open mind on all of these questions should arise. But I think I'm with Advocate General Bobek, really, because the way I see it is this, is that both the TFEU and the Charter are fundamentally, in this respect, addressed to the member states and not to private individuals. And that the failure to transpose the directives correctly is the responsibility of the member states and not private individuals. So therefore, why should a private individual, as a matter of, if you like, ordinary justice, be responsible for the failure of, let's say, Austria in Cresco Investigations to align its employment law with the principle of non-discrimination? It had no responsibility for that. Now, as it happens in Cresco, the sum of money was very small, perhaps €100 or thereabouts. The sum of money in Smith, the damages were very substantial. All right, you could say a big insurance company, but it's not impossible that you would have a situation whereby a private employer, perhaps with, a small company or an SME, could be exposed to a very large claim of a sort of a Cresco investigation style claim in respect to something of which he had no personal control. And that's the difficulty that I have. In other words, if you take the view that as a matter of justice, the entity which is legally at fault should carry the can, well, then I think that suggests to me that the responsibility should be with the member state. In other words, yet another way of looking at this is to say nobody's saying that in Cresco the employee shouldn't have got this additional pay for working Good Friday, or that the poor unfortunate plaintiff in Smith should be deprived of liability, of an entitlement to damages which he would have had under the Motor Insurance Directive. Nobody's suggesting that. The real issue is who should bear the responsibility for the failure to, say, transpose the Motor Insurance Directive correctly, or in the case of Smith, or in Cresco, the failure on the part of the Austrian state to align its law with non-discrimination. It's the member states in both instances. And I contend that really what should happen, the better solution is that those member states should pay Frankovich damages. And that, I think, if you had an effective remedy under Frankovich in that situation, I would suggest that might be a better solution than the one that has been suggested in some of the recent case law.
And just hypothesizing, would you imagine that this would require in some or all member states the establishment of a procedural rule that would make it easier to claim Frankovich damages? Because I imagine... Yeah?
I don't think that as such should be the problem. The real problem, I think, with Frankovich is that you can only get damages where essentially there has been a grave and manifest breach of EU law. And, I
would imagine that
that's something that's difficult to establish, and people have different views as to breach of EU law. Mm-hmm. But I mean, come back to the problem, saying Cresco investigations. Supposing there'd been 1,000 employees or 1,500 employees who were affected by this law, should the employer have to pay, a rather significant sum of money in that situation? Or is it the kind of loss that really a member state should bear? Because after all, they were the people who failed to comply with their obligations in the first place.
Okay. Yes, that's really interesting. Because when I think about those issues, I always imagine that the duty of conform interpretation is perhaps the least controversial application of EU law for judges, followed by direct effect, followed by Frankovich or Brasserie de Pêcheur liability, because I imagine a lot of judges would be quite reluctant to impose financial penalties, non-contractual penalties against member states.
Yes, I mean, I can understand that, but why should we be more prepared to transfer the burden onto private individuals who had no responsibility for this in the first place? But yet that's what happened in Cresco. And it seems to me, as a matter of ordinary justice, difficult to align a situation whereby a member state could say, well, I'm not liable for Frankovich damages because even if I was in breach of my obligations vis-a-vis the transposition of the directive or vis-a-vis the charter, it wasn't so obvious that it was a manifest breach of EU law, such would trigger Frankovic. But at the same time saying, well, tough for the employer, but giving a Marleasing interpretation, an interpretation conforme, and therefore, even though the employer was just following the letter of the national law, it suddenly found that that's quite different because of the way in which the national laws had to be interpreted in order to comply with the directive or the charter, as the case may be.
Mm-hmm. Okay, well, thank you very, very much for that. So just to summarize in one sentence, if that's even possible, we have a private action in a national court in Poland or Slovakia. How would you describe the current state of the law if there's a national law which arguably violates EU law, violates a directive right?
I think the first thing you have to ask yourself is, in the light of this recent case law, and Smith here is critical, is the national law giving effect to or mirroring a general principle of EU law or provision of the Charter? In that situation, you can press for a Marleasing interpretation, even as against a private individual. If, on the other hand, the directive does not concern a general principle of EU law, well then you can have Marleasing, but only up to a point, and not where it would be, in a sense, contra legem. In other words, where the national law is clear and precise and doesn't admit of this interpretation conforme, well then it would seem that Marleasing doesn't apply and national law takes effect, even though that national law might itself be inconsistent with the provisions of the directive. And in that situation, you'd have to ask yourself whether there's the possibility of a Frankovic claim.
Perfect.
Now, I stress none of that is legal advice or anything of the kind.
Absolutely.
But that seems to me to be the present state of the law, looking in the round at the recent cases.
Perfect. Thank you very, very much for that analysis. So just one final question. Here we are in the times of the coronavirus. How has the lockdown affected the workings of the Court of Justice?
Well, it hasn't been easy for us just as much as it hasn't been easy for anybody else. To some extent, the court can manage a little bit better than perhaps national courts can, because we don't really, certainly at Court of Justice level, whatever about the tribunal, we're not involved in the gathering of evidence. In essentially everything is, so to speak, pre-cooked for us. It comes generally in a nice legal question based on evidence which has been tried and tested in the national courts. And I think what it has done is to accelerate a trend which has been increasing in any event, which is for paper disposition without oral hearings in Luxembourg. Now, on the other hand, we have one complication which places at a disadvantage compared with national courts. I'm aware in Ireland, for example, and I think in other member states as well, appellate courts can have remote hearings involving Zoom and other types of technology, such as we're having now. More difficult maybe for trial courts, but certainly appellate courts can do that. We may have to give consideration to remote hearings, but there is the further huge complication with us of the multilingualism. And that's a very important and core principle of the Court of Justice, that everybody's entitled to plead and argue their case in their own language. And, it might be one thing to say, if like big, without any disrespect to any language, one of the big languages, it becomes more difficult where the language is perhaps peculiar to one member state and is not spoken really outside of that member state. That presents, in terms of translation, a lot of difficulties.
Of course. Wow. Well, thank you very, very much. On behalf of our viewers, also thank you so much for joining us today, and answering those questions that I had on the issue of horizontal direct effective directives.
Yeah. And could I just stress that, Rory, thank you very much. None of this is in any sense legal advice. None of this is binding on me. I reserve the right to change my mind at any moment, and it isn't necessarily an indication of how I might take a view in my judicial capacity. It's my endeavour to give a summary as to where the law stands at the moment.
Absolutely.